implicated, she afforded them an opportunity to respond. The president had responded on the 28th of February 2017, and the presidency had sought a meeting to take place on 25 April 2017. When I come to the Constitutional Court judgments, there is a correction of an error, which I won't correct at this stage, and I'm saying so that Advocate Mpofu is alerted that I will deal with it in the Concord judgment when the error is corrected. But what was before the full bench is raised that during the meeting, the public protector became concerned that her draft remedial action to direct the president to establish a judicial commission may face similar difficulties that was being faced in what was then a challenge to the state capture report. And accordingly, that was then amended in the report to reflect a recommendation in respect of the SIU. Further, that the agreement that was the subject matter of the investigation was an agreement between CX and the government, and it was then signed by the then Director General of the South African National Intelligence Agency, the predecessor to the SSA. And so, according to the public protector, it was necessary to have a follow-up meeting with this entity to confirm the agreement and to inquire why the SSA failed to follow up the matter on its implementation. Right? So, the fact that these meetings took place wasn't really in dispute before the court. What was an issue, and wasn't also in dispute, that neither ABSA nor the Reserve Bank had known about these meetings, or that they had had similar meetings. It also wasn't in dispute that the public protector had not attached transcripts of those meetings. So what the court then said was that the context in which this had to be considered was the public protector's report, and that the public protector had disclosed under the heading correspondence sent and received that there was correspondence between her and the presidency. And under the heading interviews conducted and meetings held, that there was a list of meetings held with various persons, including the meeting for the SSA on 3 May 2017. The court then said it was, however, important to point out that there was no reference to any meeting with the presidency in the report. It was only in her answering affidavit that she admitted to a meeting with the presidency on 25 April 2017, but that she was silent on the second meeting, which took place on 7 June 2017. And that the only way the reviewing parties had become aware of this meeting was because of a handwritten note that had been included in the Rule 53 record. In addition to this, that during the meeting which she had with the SSA, the issue of the vulnerability had arisen. And this they had become aware of with regard to the Rule 53 record. So the court concluded that the public protector had not given the same opportunity to consult with the reviewing parties or to allow them the opportunity to respond to the adverse findings that directly implicated the Reserve Bank and ABSA in the report, and that it was indeed so that the findings so implicated them. Right? And the court then said, if it was an oversight not to have afforded the Reserve Bank and ABSA a further hearing, then they would have expected the public protector to have said so in our answering affidavit. Taking all of this into account, they said, having regard to all of these considerations, we are of the view that a reasonable, objective, and informed person, taking into account all these facts, would reasonably have an apprehension that the public protector would not have brought an impartial mind to bear on the issues before her, and then concluded that there was a reasonable suspicion of bias. So the court had regard to the following in addition thereto, that the public protector had relied on new reasons in her answering affidavit, which did not accord with the reasons she set out in her report. She justified her findings ex post facto in the answering affidavit. She attached documents that were not filed and were not included in the record of proceedings filed in terms of Rule 53. And her averment that she had received advice from economic experts while compiling the report was doubtful. Dr. Mokoka's report was only obtained following receipt of the review applications. So the court reiterated the position that the public protector had a heightened obligation to be frank and candid when dealing with the court. They concluded that the public protector had 2 meetings with the presidency after the release of the preliminary report, but failed to address the second meeting and failed to disclose what was discussed. Secondly, that the meeting with the SSA and the former Minister of State Security on 3 May 2017 and the discussions pertaining to the Reserve Bank could not be justified in any manner. Thirdly, that she had engaged directly, that she should have engaged directly with the Reserve Bank if she was concerned about the security of the Reserve Bank. And further, that she had failed to record these meetings, although it was customary to record all meetings. So the court concluded that whilst that the public protector did not conduct herself in a manner that should be expected from a person occupying the office of the public protector. Even so, it didn't make a finding or declaratory order that the public protector had abused the office, and she didn't do so because that relief had only been sought in reply and it wasn't procedurally before the court. That relief had been opposed by the public protector because as an inappropriate attack on the public protector and as relief that sought to undermine the office, the institution of the public protector. Counsel for the public protector had argued that it had not been proven on the papers that the public protector had acted in bad faith. She had no malice or sinister purpose when meeting with the presidency and the SSA without alerting ABSA and the Reserve Bank that she had done so. And the question remained unanswered, the court said, as to why she had acted in such a secretive manner, and she did not give an explanation to do so. It then said that it's possible that the public protector had not taken fully the court into its confidence when deposing to the answering affidavit, when she set out, when I make averments relating to economics, I do so on the basis of advice received from economic experts during the investigation of the complaint referred to below, which advice I accept as correct. Dr. Mokoko's report, the court held, was obtained after the final report had been issued. It was against this factual background that the judgment took these factors into account when it came to the issue of costs. And it concluded that the public protector did not fully understand a constitutional duty to be impartial and to perform her functions without fear, favor, or prejudice, and that she had failed to disclose in the report that she had a meeting with the presidency on the 2 dates referred to. Further, that she had failed to make a full disclosure in her answering affidavit when she was saying that she was acting on advice received with regarding to averments relating to economics prior to a report. We had already pointed out that Dr. Mokoko's report was obtained afterwards. And thirdly, it was in light of this that the court considered a punitive cost order and had went further than simply a punitive cost order, and in fact ordered that the public protector should pay 15% of the cost of the Reserve Bank and the office should pay 85% of the cost on an attorney-client scale. The PP sought, the public protector sought leave to appeal to the full bench of the SCA. That application was dismissed. Direct access, alternatively leave to appeal directly to the Constitutional Court was sought. And that leave was then granted and they argued before the Constitutional Court. Now, there were further affidavits filed before the Constitutional Court that warrants a separate explanation and would put some of what was not said before the High Court into a different context. And when we deal with this again, I will deal with the Constitutional Court judge. Thank you.
Thank you, Advocate Bauer. I now recognize Ms. Fatima Ibrahim.
Good morning. Thank you, Chair. I'm Advocate Lula. Can you hear me?
Yes, I can hear you, ma'am.
Good morning. I'm Advocate Lula. You have been invited, subject to the provisions of Section 16 of the Powers, Privileges and Immunities of Parliament and Provincial.
So just a pause, Ms. Ibrahim. We're just fixing so that he keeps his mic on and closer to you, possibly. So yours will stay on. So
Recording in
don't worry.
progress.
Thank you. Start again, Ms. Ibrahim.
Thank you. You have been invited, subject to the provisions of Section 16 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act 2004, to appear before this committee as a witness and to answer questions in respect of the committee's inquiry into the removal of the Public Protector, Advocate Mkhwebane. Please be informed that by law you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of this inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. You are, however, protected in that evidence given under oath or affirmation before a House or committee may not be used against you in any court or place outside of Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware further that in terms of Section 17(2) of the Powers Act, a person who willfully furnishes a House or committee with information or makes a statement before it which is false or misleading commits an offence and is liable to a fine or imprisonment for a period not exceeding 2 years. Advocate Chiwalula, I will now require you to either take an oath or affirmation that the evidence you are about to give is truthful. Which do you prefer?
I'll take an oath.
May I please ask that you raise your right hand and repeat after me? I swear that the evidence I shall give
I swear that the evidence I shall give
shall be the truth, the whole truth, and nothing but the truth.
will be the truth and the whole truth, but nothing the truth.
But the truth, so help me God.
So help me God.
Thank you, Mr. Chiwalula. Chair, the witness is now duly sworn in.
Thank you, Ms. Ibrahim, and thank you, Advocate Chiwalula. You nearly tripped there in the whole truth and nothing but the truth, and kind of turned around. Hopefully it won't affect what we're dealing with. So please relax and just stay focused. Thank you very much. I now recognize Advocate Mayosim, and to indicate that I am allocating you a certain amount of time. You don't have to use it when there's no need. Between now and lunchtime, you can finish at any time before that. Thank you.
Thank you, Chair. Good morning, Advocate Chiwalula. Good morning, members. And good morning, members of the public. Earlier this morning, we had word from Advocate Mbofu's camp that there are certain aspects of the affidavit of Advocate Chiwalula that are common cause, that are not in dispute. I will nevertheless take you through those aspects that are not in dispute just for context for the committee. Paragraphs 1 to 27 of the affidavit, they indicated are not in dispute. But as I say, just for context, I'll take you through those and I'll lead you through those quite quickly so that we get through those items. So Advocate Chiwalula, you state you're an admitted advocate, right?
Correct.
But you're not currently practicing as one.
Correct.
So you joined the PPSA in about 2014, correct?
Correct.
And when you joined the PPSA, the CIX investigation, it was pretty much already started, correct?
Correct.
Would you say it was already in a substantial stage?
Yes, it was already in a substantial stage.
Yeah, can you tell the committee at what stage it was, what interviews had occurred, what interviews had you been part of, had you not been part of?
Okay, so when we started with the investigation, or when I joined the investigation, there had been a number of interviews that were already done with a number of people. The one that I can recall is that there was an interview that had already been done with former Reserve Bank Governor Tito Mboweni. There was also an interview that had already been done with former Reserve Bank Governor, I think as Gil Marcus. There was also an interview that had already been done with Dr. It was the complainant at the time had already been engaged. There was also an interview that had already been done with the author of the CX report, which is Michael Otley. Those are the ones that I can recall now. And then the interviews that we did with Advocate Madonsela, we interviewed former Finance Minister, I think Trevor Manuel. We interviewed the former CEO of ABSA, Maria Ramos. We interviewed the former Reserve Bank Governor, Dr. Christals. We interviewed former Director General in the Presidency, I think it was Frank Chikane. We interviewed former President Bay. We also had an engagement with other officials within the Reserve Bank who were obviously assisting with the investigation as well. Those are the people that I can recall that we did interview during the period that I was working on the investigation.
Okay, so we skipped a bit there, but when you joined in 2014, you joined as a trainee investigator, is that right?
Yeah, yes, then quickly after that, I was then appointed as an assistant investigator. Later on, I was then appointed as an investigator.
And you worked with who?
I worked with, previously I was working with Advocate, the former Deputy Power Protector, Advocate Malunga, in the private office. Then later on, then I directly worked with Advocate Madonsela.
And you say in your affidavit that you were involved in in some of the big investigations that were happening at the time, right?
Yes. Yes, yeah, I was a part of the number of investigations that were taking place in the office of the Power Protector, simply because whenever the PP would go either to a province or a particular unit where an investigation is being conducted, I would then be the person that obviously go in, then assist her. And the same would happen with the Deputy Power Protector. So I was part of the CX investigation, I was also part of the state capture investigation when it began the time.
Right. So in paragraphs 8 and 9 of your affidavit, you set out the process of drafting and producing an investigation report. And you talk about quality assurance until the report is finally done. So at the time when you were in the private office, after Advocate Mkhwebane arrived, the think tank and the quality assurance function happened concurrently? They were still existing at the same time?
Correct.
Okay, and what would happen then? Can you just briefly just detail for the committee that process of producing a report?
All right, thank you. So ordinarily, the report will be drafted by an investigator from a particular unit or a particular province. That report will then sent to the quality assurance team. The quality assurance team will then be responsible to table the report at the think tank meeting. The think tank meeting comprises of the heads of provinces, or what the Power Protector's office will call provincial reps, and all the senior managers and executive managers in the Office of Power Protector, chaired by the Power Protector. We would also play a role of being the secretariat. And when I say we, I mean the team that was obviously assisting the PP together with the quality assurance team will then put together that. The purpose of the think tank when I was there was mainly to obviously look at the quality of the reports. This would be to check if all the processes have been followed in line with the standard operational processes that were established at the time when I was there. So it was to look at the facts on the report, look at whether the laws have been applied properly, case laws that probably would have been considered in the report, whether they have been applied properly, the language of the report, the tone. it also had a role to play in as far as suggesting names of the reports. You'd recall that at the time, Advocate Manzela would have catchy titles of the reports. So that committee will then be responsible to say, well, in this particular report, we think that to assist the reader of the report, this will be a catchy name that will then obviously inform the reader before they even go into the details of the report, what the report will talk about. I mean, for example, we'll talk about derailed, which was the PRASA report. That name came from the whole process that took place through the think tank. There were also suggestions that I can talk about, which I find interesting at the time, which obviously some of it you might obviously know about it because it was happening internally. There was a report that we were working on before I left, or a section 7.9, where we had already started to suggest names about how we should name the report. The Mandela funeral one, I think is the Eastern Cape investigation, where I had already started suggesting names like Not in My Name, or I Didn't Die for This. Those were the names which I thought that report would invoke the spirit of Madiba in a way that people would have looted resources under, his name, where they were saying to bury him, this is what we are going to be doing. So there were those kind of catchy names that we had at the time at the think tank, where there would be ideas that come from different people from around the country who are senior officials within the Office of the Public Protector.
Okay. And you say in paragraph 9 that the last say on any report rests with the PP. By this you mean the PP, whoever it is finally accountable for the contents of a report, correct?
Correct.
Okay. And then in paragraph 10, you begin to talk about the CIX report, and that on the 13th of October, you then emailed a copy of that report to Advocate Madonsela, right?
Correct.
But there was further work that still needed to be done on it. Can you just tell the committee what further work still needed to be done on that draft?
Okay. We had interviewed Dr. Stiles, the former Reserve Bank governor, I think somewhere around September, if I'm not mistaken. And he had given us so much information. Part of that information was that we were actually not in the right track in terms of our argument that there were no monies that were repaid. And he then indicated to us that he's actually going to prove to us that in terms of the loan, ABSA did pay that particular loan, and he'll prove to us. So that information was submitted to us somewhere late September. I felt that we didn't have enough time to go through that whole evidence that was provided to us to obviously be able to say to the Power Protector or the former Power Protector, this report could go through and be signed. There were also issues that we needed to do relating to research and case law, which had not yet been done at that particular time. So those were the issues.
Okay. And you do say that Advocate Madonsela then responded to you. She responded to you by way of a covering email where she, you had said to her that there were some interviews that you had not attended, and you required some input from her relating to the inputs from those interviews. She then responded and she told you what had happened in those interviews. And she also, you say in your affidavit, she also gave you a hard copy version with some handwritten notes. What happened to the version with Advocate Madonsela's handwritten notes?
Okay, I incorporated the changes that were on the end, on the document that she had written on in the draft report.
Yeah,
that's what I did. I
in the handwritten notes.
Yes, in the handwritten
Okay.
note. Yeah.
Will you go to LT3, page 3217? Sepo? Yeah. So that was Advocate Madonsela's response, right?
Yes.
Down. Yeah. So she then responded, interview parties these are the interviews that she had attended that you had not attended, right?
Yes, I was not party to this.
Right.
Interviews.
Did you incorporate these changes into the report?
Yes, I did.
Okay.
I did. I think those appear in my, they appear on page 3365.
The Billy Masetla changes appear on 3365, right?
Yes, yes.
And the Praveen Godam changes appear on 336,
64.
page 33664, right?
Yes,
The Bertelsmann changes appear on page 3359
yes,
of the record. The Oatley changes on 3359 as well.
yes.
The Michael Durr changes on 3359 and so on, correct?
Correct.
All right. Then on the same, later on the same day, there was a letter from Chris Moraitis of Worksmen's. Will you just tell the committee what that was about?
Yes, so we received a letter from the attorneys that were representing Upside at the time, so Reserve Bank at the time, and they were inquiring about the release of the provisional report by the protector, and this was because the 14th, I think it was the last day that the PP, was in the office, and obviously they needed to understand whether the report was going to be released and whether they'll be afforded an opportunity to then comment on that. So that was the reason why we got that particular correspondence.
Right. But you say that after that, you were then requested by the PP's PA. The PP was requesting a briefing from you regarding the reports that were finalized by her predecessor that had not yet been released. Did this briefing occur? And can you just tell the committee what happened at that briefing, if it did occur?
Yes. So what happened is that soon after the PP was appointed, I got a call from the PA saying I have to brief the power protector. This was because at the time when the former PP left, we had a memory stick in the private office that kept all the reports that were supposed to have been released. This includes Section 79 letters that were supposed to have been released. And the former PP had already indicated to me that when the new PP comes through, she will obviously have a handover with her. But there are documents that we need to hand over to her, which she did not manage to release when she was still in the office at that particular time. The briefing did happen. I did brief her. And I indicated to her that the report had not yet been finalized. There were also changes that were already made by Advocate Matonzela, which I had already obviously inserted on the report. I went to her office. I met with her. I downloaded the reports or gave her the reports that were on the memory stick so that she can have sight of those. It was during this period that she then indicated to me that there was a pressure from society. And this pressure, I think, she then indicated that there was pressure from society at the time regarding this particular report. I understood this pressure to mean that before Advocate Matonzela left the office, I think a month or so before she left the office, there were a number of organizations that were camping at the office outside. We had also complainants who were some of them threatening to sleep in the office at the time because their reports had not yet been finalized, and Advocate Matonzela, now that she's leaving, they might not see the light, those reports and everything. And there was an organization called Black First Land First, if I'm not mistaken. I might not be pronouncing it properly there. That organization had a very keen interest on this investigation. And she did mention that they'd already reached out to her about this particular investigation. I explained to her at the time that obviously there were changes that I had not yet finalized in setting. I finalized them and that I was providing that report to her following the changes that were already suggested by the former PP. I handed over the report to her in that regard.
Okay, so you handed the report to her together with the changes that had been suggested by Advocate Matonzela incorporated into that draft.
Correct.
All right. And then you carry on in your affidavit and you say you had another discussion with her in November. So you had a number of meetings with the PP discussing the report?
Yes, correct.
Okay. Can you just tell the committee if, and you do allude to this in your affidavit, if at any point during these discussions, you handed over documentation to the PP relating to the investigation?
So after I had handed over the draft report to the PP, she requested that I should also hand over the evidence. I went to her office and handed over the boxes, the 2 boxes of evidence that we had at that particular time. And I asked her whether she still needed or required more time, because I was seeing that she had been with the report for a while, and I asked her and she indicated that she still needed to go through the report. She will advise once she's done. I recall handing over the evidence to her at that particular time, the 2 boxes, the evidence. I sent the information that was in the boxes to her. If I recall well, it included transcribed interviews of the meetings that we had with the officials that we interviewed. It also included some of the documents that were submitted to us by some of the people that we had interviewed at the time.
Yeah, so you handed over,
Yes.
are you able to recall now the specifics of the documentation you handed over to her?
Yeah, the ones that I can recall right now are the transcribed interviews for all the individuals, or some of the individuals that I know we had already done the transcribe of their interviews. There were several correspondences that were sent by Michael Otley at the time, where he was inquiring why the government was no longer proceeding with him and in the investigation that he had done, because he had already given them a prelim report, and he thought that they would continue with the agreement for him to finalize the investigation in other things that he had already raised with them. So those were some of the documents that formed part of the information or in the box that I handed over to the PP at that time.
Okay,
Yeah.
and then on the 25th of November, you got alternative employment with your current employer, and you told the PP about this, right?
Yes.
And she, of course, naturally was concerned about you dealing with all the reports that you had under your control and handing those over properly. Is that right?
Correct.
Right. And then can you tell the committee about the request you received from her on the 7th of December to do some further research on other countries' reserve banks?
Okay, thanks for that question. Chair, I received an email from the PP requesting me to do further research on other countries' reserve bank and some obviously indication on how they are controlled or whether the state has any control over those. I did that research. I looked at a number of central banks around the world. I checked the US one. I did look at China. In the African continent, I did look at Nigeria, simply because at that time I think it was I'd considered it to be a leading economy in the African continent as well. I also look at the Russia one and also Zimbabwe. Those were the ones that I did look at. I didn't understand this. I must obviously clearly indicate I didn't understand this because there was no link between the complaint that came from Paul Hoffman or Mr. Advocate Paul Hoffman and this request. And one had to comply, obviously, just to say we will look at this. But I didn't understand where we were going with this, because the issue from the complaint had nothing to do with what obviously was what she was asking. Nonetheless, I obviously proceeded to do this research and look at how other central banks around the world deal with the issue of obviously control in as far as whether they are nationalized or state-owned or they are privately owned in that regard.
Okay. And then you say on the 20th, you emailed the finalized report to her Chief of Staff, Ms. Linda Mulelekwa, and as well as Tebogo Kekana. What role was Tebogo Kekana playing in this at the time?
Okay, so soon after I tendered my resignation, which was in November, end of November, I was then told by the chief of staff of then, Ms. Linda Mulelekwa, that because I'll be leaving that office and there's so much work that I was doing as far as some of the investigations the private office are concerned, they are now going to bring in Mr. Kekana to then assist with the work that I was doing. And I must then do a proper handover to him. And that was in that regard. I understood it to be in that particular way, that Mr. Kekana was then brought in.
And then what happened after you submitted the report to him and Ms. Mulelekwa?
The PP then signed the report on the 21st of December. The report was signed together with the Section 79 covering letters. These are covering letters that obviously would be together with the report directed to the implicated parties so that they are able to see what the PP's findings are likely to be, and also what the proposed or the likely recommended or remedial actions would look like in that regard. So at least they have an opportunity to comment on that. So the report was then emailed to the implicated parties.
Can you remember who you sent the report and Section 79 notices to? Who were the implicated parties in your recollection?
Okay. I remember sending the report to the office of the president, I think the presidency at that time. The report was also sent to APSA. The report was also sent to Reserve Bank. The report was also sent to the Minister of Finance. Yeah, those are the parties I can recall now.
And you sent the report and the Section 79 notices to those parties, right?
Correct.
Right. So you know who the complainant was in this whole matter, right?
Correct.
Can you just tell the committee who it was?
Okay. The complainant was Advocate Paul Hoffman from an organization called Accountability Now. That's all I can remember.
Did you send the Section 79 notices and the report to the complainant?
No, I didn't.
And why did you not?
Okay, so Section 79 letters, by their very nature, they are sent to implicated people for them to comment. There was no reason from my side that I saw that the report should be sent to Mr. Paul Hoffman. The only thing that was supposed to happen, which I think it did happen when he made an inquiry, was just to update him that the PP has now finalized the provisional report of Section 79. That has been now sent to the parties for comment. They've been given 14 days to comment. So at least he then get the progress of where the investigation is in as far as that is concerned. And that was done. I remember that was done because when I got a call late December, I think around the 28, 29, I did advise the PA of the PP at that time that there was this call that I received talking about somebody not receiving the report, and this was a complainant at that particular time, and that we just need to update the complainant, not to give him the report, because there has always been an issue about leaking of reports by individuals in that regard, especially those that are not implicated. If you just share the reports with them.
So it is your evidence that you did not provide the report to the complainant because they were not an implicated party in the investigation.
Yeah, correct.
Right. Okay. In your affidavit, you also deal with the issue of prescription. If we go to paragraph 34 of your affidavit,
Okay.
and you explain in that section that you and Advocate Matansela had a different view regarding the issue of prescription in the report. Can you just explain that to the committee, please?
Okay, so when we were discussing the possible remedial action that obviously had to be put in the report, I had several engagement with Advocate Madonsela about this. We obviously didn't share the same view. I was entirely convinced that the debt was recoverable. That was my position, which is a position that I advanced. She shared a view that the debt can't be recovered because it is prescribed. I decided that particular time that I'm going to give Advocate Madonsela two versions of the report. One that says this can be recovered, and that if anything, prescription should be raised by those that we are saying they should, the monies should be recovered from them and not us. We should not become the ones that argue the defense of prescription, but rather the implicated party is the one who must say, well, this debt is already prescribed. Advocate Madonsela didn't share that view. Her view was that we can't recover here, because the claim is already prescribed. I prefer the version that find expression in the provisional report. That was my preference, that there is something that can be done to recover this owed amount of money.
Okay, so we'll go to page, to LT4, page 3220. 3277. 3277, yeah. Paragraph 7.1.6. Go up. Yeah. So this is Annex LT4 to your affidavit, which is the draft report that Advocate Madonsela left behind, correct?
Correct.
Yeah. So just go up, Tsepo, just so we can see 7.1.6 in totality, up or down or whatever. Yeah, yeah. So is that the manner in which Advocate Madonsela preferred to deal with prescription?
Correct.
That's the report that she left behind.
Correct.
Okay, but you had a different view, as you've explained, correct?
Correct.
Okay, so I just want to juxtapose that against the view that the current PP had in relation to prescription. So we'll go to page 3373. Paragraph 7.2.3. Yeah, just show us the whole thing. Yeah. Was this the view that you supported? This is how the matter was dealt with in the provisional report that was released on the 21st of December 2016.
Yeah, correct. Yeah, I supported this.
Is this the view that you supported?
Yes.
And that you discussed with the PP?
Correct.
Right.
Yeah.
Was it you who introduced this change to the draft, to the provisional report?
Yes, I'm the one who did that.
Okay.
Yeah, and I think just to qualify this or to explain this, so there was a discussion I had with the PP about the recovery issue and everything, and I was saying the argument came the angle of saying what should be the amount, because I mean the agreement between Reserve Bank and ABSA was that the interest must be paid within a period of 5 years. if my memory serves me well, but I think those documents should be obviously with the committee here, that particular agreement. Now, years have gone by, you know, after the 5 years had passed in terms of that whole agreement, and the interest had not yet been paid. And the argument was, how much will that be? So the argument from my side was, it is, you know, there is a common law rule that says you can't, interest can run over the capital amount for the loan. So if you are owed 500 rand, or you're owing someone 500 rand, and the interest would then start to run, the interest can then be more than the loan that you have received. So it immediately, when it gets to the capital loan, it then stop running. That was the argument at that particular time. Thanks, Chair.
I apologize for interrupting, Chair. I just want to get a clarity. Which public protector did the witness make that submission to? To Advocate Mkhwebane. Thank you, Chair.
So the witness's evidence is that he differed a bit with, on the issue of prescription with the former PP, and he had discussions with the current PP about those two versions, and yes. So going back to your affidavit, go back to his affidavit, please, Sepa. Yes, paragraph 39. Yeah. Yeah. So when you were conducting the investigation with Advocate Madansela, did she engage the services of an economic expert at all?
No.
Okay. And then in your affidavit, you go on and you talk about the meeting with the PPSA officials. Paragraph 42. Yeah.
Paragraph is that?
Yeah, yeah. How did this come about, and why did this come about? And can you just tell the committee about this?
42.
In early 2017.
Okay, so after I left the office of the Park Protector, the preliminary report was then leaked, and it was in the public domain, and people were talking about it. The media was writing a lot of articles about it. Advocate Mkhwebane then wrote to my new employer, requesting to meet with me to iron out a few things relating to the CX investigation. I had a meeting with the Power Protector in January, if not February, 2017. We were supposed to meet with the PP in person in Pretoria. When I arrived, I was then told that the PP is in Cape Town. She's appearing before the, I think, the Justice Committee. We had a virtual meeting. She was linked from the boardroom. We were in the boardroom, and then she was linked through Skype. Present with me in the meeting was senior investigator at the time, Mr. Isaac Matlaun, with Mr. Kekana, who had already taken over from me, as well as the chief of staff there, Ms. Linda Mulelekwa. Those are the people who were in that particular meeting. The PP had, the connection was not quite good at the time. When she was joining the meeting, she was quite brief in that meeting, and she lost connection. We then nonetheless continue with the meeting. Then that's when I was formally informed by Mr. Kekana that he has now been appointed or formally, asked to take over the investigation, and that he was not that much familiar with the things that were happening during that investigation, and that I should avail myself as and when the office require me to assist them with the investigation.
Yeah, so So in your explanation, in your affidavit about what happened at that meeting, you say that they obviously wanted clarity about various things. They wanted to know about the transcripts of interviews.
Yes.
Can you tell the committee about that?
Yeah, I was then asked that there were several transcripts that they couldn't find and information that they wanted, which is not in the box that I had handed over. As I've indicated, Chair, before I left the office, I had handed over everything, including my laptop and everything, all the documents that we had during that particular period when we were doing the investigation. So the number of questions that were asked to say they wanted to check where the transcribed interviews of some of the witnesses that we had interviewed during that particular time. And also there was an issue of the provisional report, why the provisional report was released as opposed to Section 7.9.
Can you explain that? There seems to have been a misunderstanding where it appears that there was a view that it shouldn't have been released in the form that it was released, but you had a different view?
Yes. I think in November, the think tank said in November, it took a decision after several leaks that were taking place in the office of the power protector that we are no longer going to be releasing provisional reports, but rather will then issue Section 7.9 notices to the implicated parties. In that meeting, I reminded those who were in attendance of the resolution that was taken in that meeting and its ambit in terms of the CX report and other reports, that the CX report did not really fall within that resolution, as it was already in the private office and the PP was already finalizing it. And there were other reports that were signed within that particular period. I remember the Maranda report, which was also signed. It was an investigation that was done by, I think, Advocate Niels van der Merwe. It was a provisional report that I facilitated when it was sent to the private office for the PP's signature as well. So that's in brief what I indicated to them, to those that were in attendance of that meeting. I remember that time when I mentioned that the PP had already been cut off in that because she had a problem with the connection through Skype.
Right. So the PP herself, in fact, signed the provisional report as well as the Section 7 and 9 notice.
Correct.
Of the 21st of December. Did she indicate in any way to you that these were not to go out in that form?
No.
Okay.
No, she just indicated that I should send, and when I'm sending out those reports, I must copy Mr. Kekana. You would see in the emails that when I send out the report that Mr. Kekana is copied there. The chief of staff is copied there, and I think PA as well. So she indicated that to make sure that when they respond, because I won't be there, the 31st of December was my last day. So when the responses are coming through, at least they should be able to, there should be someone who is going to be able to receive those responses from the office.
Yeah, but you also say in paragraph 45 that they were, the PPSA officials that you were meeting with on that day were also asking you about the contents of the provisional report, and you couldn't really assist them in that regard because, as you say, in your view, the contents of the provisional report were materially different to the reports that was left behind by Advocate Madonsela. Is that right?
Correct.
So I'd like you to be more specific about this, please, for the assistance of the committee, these differences, which in your view, you felt were there and were material. And just for the benefit of the committee members, we're going to be fleeting a little bit between the provisional report that was left by Advocate Madonsela and the draft report left by Advocate Madonsela and the provisional report released. So bear with me because we're going to be going through.
You do that through the chair. so that you are able to address all the members.
Thank you, Chair. Thank you, Chair. I just thought that I should explain the confusion that might ensue. So, and of course, I'm going to lead you on this because you've sort of shared what you say the material differences.
Yes.
Tsepo, if you go to page 3316, please. Right. This is the provisional report released on the 21st of December, correct?
Correct.
Can you talk about the contents of that page?
Okay. So the way it reads, I think the primary function of the Reserve Bank, if you look at the one that was the draft that the PP, the former protector left, it differ with this paragraph. It completely differ with this paragraph.
Sorry, which paragraph? Paragraph X.
Yeah, XI.
X11, that's paragraph
X11.
12. I
Yeah,
think
it's
Roman
X11,
numeral
yeah.
12, I
Yeah.
think, yeah?
Yeah, numeral 12.
Yeah. Is that the only difference?
There's also section, I think it's section 5 of the executive summary.
Of the executive summary,
Yes, section 5 of the executive
go-
summary
go up to-
completely differs with the one that
Go up.
was left by Advocate Matonsela.
Go to section 5 of the executive summary, which is sorry. It's section 5 of the executive summary you say is completely different. It's at page 3327, Tsepo.
It's 3315.
Sorry, 3327. Yeah, 27. Is it, Mr. Advocate Chiwalule, is that the section 5, starting from paragraph 5 there?
Correct.
And going down, is that an entirely new section from?
Yes, it is entirely a new section.
Okay. Right, what other changes are you able to see in the report?
Okay, on the remedial action, there is a change there that I noticed, I think, where it says National Treasury and SAB to institute legal action.
So what
Trying to
paragraph?
check the paragraph, just hold for a moment.
Remedial action.
Yes, remedial action.
Do you have a page there?
Just a moment. So I think it's it should be on.
Look at the top of your affidavit. The page.
Yeah, I think it's 3318.
3318.
Yeah, it should be 3318.
Okay. Go step up 3318. Which remedial action are you talking about?
This whole part,
Just go up.
where it's written National Treasury
Oh, okay.
and Presidency, I think.
No, go up. National Treasury, go up. Go up. 3318. Yeah.
Might appear on this 3365. Might be 3365 and 3364 and then 3359. The
So let me just help you, Mr. Shiwalula. In the section on page 3329, Tsepo, 3329. Yeah. 3329, under that section, under National Treasury, do you see that?
yes,
Under paragraph 3,
yes,
was it new?
yeah. This is entirely new.
So this, your evidence is that this was new in the provisional report and it was not in Advocate Matansela's report.
Correct.
Did you make this change? Did you add this change to the report? Paragraph 3.
Yes, I did. Yeah, that was my changes. Those were my changes.
You made this change to the report?
Yes.
Let's just go through the other changes. Are there any other changes to the provisional report that was left by Advocate Madonsela that are different to the report that was issued in December?
Yes. If you check the December draft where it talks about the evidence from Judge Petrosman,
Yes.
Oakley, Mr. Oakley and Mr. Michael Dre
Yes.
and Trevor Manuel, you'll notice that there are changes there.
Yeah, you made those changes because Advocate Madonsela told you to make those changes.
Correct.
Right? So if you go to page 317, Tsepo. 3317. 3317. Yeah. Right. Paragraph 3317, paragraph X1X. Yeah, go down. So you see that in paragraph X1X, Roman numeral X1X, it should be noted that the South African Reserve Bank disputed that it failed to recover an amount of 3.2 billion from Absa Bank. And if you go down to paragraph XX, Tsepo, South African government led by President Mbeki at the time also disputed that they failed to recover an amount of 3.2 billion.
Yes.
That is different to the previous draft, right?
Yes,
because in
correct.
the previous draft of Advocate Madonsela, those were in fact not disputed claims. Is that correct?
Correct.
Did you make those changes?
Nope. I didn't make those changes.
And then of course your testimony is that the executive summary section 5 is all new.
Yes.
Right. Can you go to page 3329, Tsepo? Yeah, he's already given evidence that that section 3 is new in the sense that it was not in Advocate Matansela's report. Is that right?
Correct.
Okay. 3374. Right. Go down, paragraph 8.2.3. And that's the paragraph that your testimony is that it's new in this report.
Correct.
Okay. So then it's your evidence in your affidavit that you then told the PPSA officials that some of the changes that were in the report that was issued, you had not been consulted on.
Correct.
Right? And
Correct.
you could not assist them with.
Yes, correct.
And then from paragraph 47 onwards of your affidavit, you talk about being visited by sub-office officials at your work. Can you, investigating a leak of the report, can you tell the committee about that?
Okay, thanks, Chair. So after I left the Power Protector's office, I was then contacted that there are subs officials, inverted commas, the Hawks, who were investigating a leak of a report in the office of the Power Protector at the time, and that when the PP laid a complaint or opened a case at Hartfield Police Station, she mentioned my name, and that's why the police wanted, to get my side of the story. Then I obviously confirmed that I sent out the report to all the parties, and that I had nothing to do with the leak or the leaking of the preliminary report. That was, I think, around March, if not April, of 2017, and this report was still in the media space. Thereafter, I received a set of questions from the National Prosecuting Authority, asking questions about my involvement and how the report was sent out and all those things. I prepared an affidavit and submitted to them. I no longer have that affidavit with me, but I prepared an affidavit and submitted. That was the last time I heard from them during that particular time. And after that, later on, I was then visited somewhere end of April. The police then visited my place of residence. They wanted to search at my house for documents. Unfortunately, I didn't have anything anyway, but unfortunately, they didn't have a search warrant. So I then said to them, if you don't have a search warrant, then you're not going to search my house. Then that was the end, the last time I heard from them in that regard. Not that one had anything to hide, by the way, but it was just an issue of saying I just can't have officials coming, police officers coming to my house and say, we want to search your house. That was the end, or the last time I heard from the police officers.
So Mr. Mkhwebane gave evidence a week or so ago, and his evidence was to the effect at paragraph 15 of his affidavit. He said that on the 21st of December, the provisional report was leaked and made publicly available. Do you know anything about that?
No.
Right. He of course continues in that paragraph, and he says that the provisional report had never been quality assured prior to it being leaked, opposed to it being released. Now you say you know nothing about a leak,
yeah.
But let's talk about it being quality assured or not before it was released. What do you have to say about that?
Yeah, I don't know what he meant by that, because the report was already with the Power Protector. So I've already explained to the committee that the procedure is there will be documents or reports that will go to the power protector without going through that process, which I have noted that when it was happening, this report was with the PP. At no point, at no stage did the PP say to me, refer this particular report to a quality assurance team. And she signed the report after having considered it, as I've indicated. To the best of my knowledge, I would not want to comment much on what he meant on that, because prior to this, he was not involved at any stage with the investigation.
Thank you, Advocate Chiwalule. Advocate Mayos will pause there and take tea for 15 minutes, back at 22. Thank you.
Recording stopped.